Hi, new MTJ class. My name is Charlotte Volet, and I had the pleasure of being supervised by Professor Sandoval for my MTJ paper. So Professor Sandoval invited me to present my paper on the case of the Reparation Plan for the 33 affected communities by the Chixoy hydroelectric plant. So today, I will hopefully shine a light on two emerging subjects of TJ. The first one is the involvement of international financial institutions such as the World Bank and the Inter-American Development Bank in transitional justice. And the second is the cohabitation of multiple reparation schemes. So before that, let me begin by giving you guys a bit of context. The Chixoy case is an atypical example of reparation. It is a program of reparation for the Maya-Achi communities living at the riverbanks of the Chixoy River that were massacred and forced by the army to abandon their land for the construction of the hydroelectric dam. The hydroelectric was constructed during the most violent years of the internal conflict, which essentially amounted to the genocide of the indigenous community. During the construction of the dam, about 800 people lost their lives for refusing to leave the land, and survivors still today live in substandard housing and have lost connection to their land. The hydroelectric dam was a state project financed by the World Bank and the Inter-American Bank. The dam also involved an array of government institutions and private companies from West Germany, Italy, Canada, and so on. With the state unresponsive to genocide claims and the companies untouchable for the lack of corporate accountability, the survivors' campaign focused mainly on the World Bank and the Inter-American Development Bank. So, Adivima and the Committee of Communities affected by the construction of the Chixoy Dam fought for justice for 30 years. Their tireless work led to the 2006 table of consultation organized by the Inter-American Human Rights Commission with representatives of the dam-affected communities and the Guatemalan government, but also joined by the World Bank and the Inter-American Bank. In 2010, a reparation plan was finalized and signed by all parties with the exception of the Guatemalan government. The plan provided a set of mechanisms, including development assistance, social and cultural support, and the environmental restoration of the river basin. The budget for the reparation plan was set at $155 million, which is about 1 billion quetzales, which is a huge amount for reparation programs. In 2014, with still no advancement made on the Chixoy Reparation Plan, the United States Senate got involved at the request of victim groups. The US Senate, through national legislation, instructed the directors of the World Bank and the Inter-American Bank to report to the US Congress on the implementation of the Chixoy Reparation Plan. The legislation also instructed the U.S. members of the World Bank to vote against any new loans for the Guatemalan army until such evidence of implementation had been presented. With such pressure, in 2014, Otto Perez Medina, the Guatemalan president at the time, officially apologized to the 33 affected communities, and the Guatemalan Congress added Chixoy reparations in the national budget for the next 15 years. The Chixoy case demonstrated that IFI's participation had a beneficial effect on the compliance with the reparation program. But what does it tell us about international financial institutions' responsibility related to sponsored atrocities? Several times, IFIs identified the state's agencies' failure to implement compensation and resettlement programs, but they still continued giving loans to the project in violation of their contractual obligations. This pattern of silence enabled the Guatemalan state to perpetrate in total impunity human rights violations. The IFI's failure to monitor the project properly has been denounced by international reports, but there's no realistic accountability for the international financial institution and human rights. In practice, the World Bank and the Inter-American Bank have participated in the elaboration of the reparation plan, but the wording of the plan does not compel them into contributing to the reparation in itself. Rather, it only holds the Guatemalan government responsible. This reveals a vacuum in international law. The Chixoy case is a great example of this, because in my interview with the director of Adivima, Juan de Dios Garcia, he shared with me that the World Bank and the Inter-American Bank have been reluctant to participate in the reparation program, claiming that it's a state duty to do so. However, he deems that it's important that IFIs be held accountable to ensure that victims' reparation are sought through. To this end, Adivima is currently working on a law project in collaboration with the US Congress. The idea would be to create a fund for reparation in the World Bank portfolio. This project would not just be for the Chixoy survivors, but also for other cases who have suffered similar harm. First and foremost, I think this project is promising to address IFI's accountability, but also possibly ensure a more thorough implementation of the reparation regimes. Multiple reparation schemes can put a great pressure on the state's institution, and this law may bring some relief. And this is what we'll see in the next part. So, Guatemala has contracted multiple obligations through domestic and international court cases for the state-perpetrated violence in the internal conflict. This in addition to the 2001 domestic reparation plan that was enacted through an executive decree. Over the years, Guatemala has shown reluctance to appropriately repair the harm done to the victims of the conflict through the National Reparation Plan and through the court cases. In 2014, the Inter-American Court even held in contempt Guatemala for refusing to comply with their judgment. The government of the President Otto Pérez Molina deliberately enacted a policy of denial of the jurisdiction of the Inter-American Court. The same year, the Chixoy Reparation Plan was signed by the government. In this context, I asked the following question: how can the Chixoy Reparation Plan, promising $155 million can cohabit with other reparation schemes? This double standard raises an issue of equity and realistic expectation of a state's capacity to finance reparations. Basically, my research showed that the government has been unable to provide effective and timely response to victims. The government agency working on reparation has been influenced by rampant corruption as well as the lack of political will in the government. So, the government's unwillingness to cooperate results in bad management, lack of resources, and budgetary difficulties. In a sense, the promise of adequate reparation is nullified. However, the Chixoy case has advanced considerably efficiently in comparison to other reparation plans. For example, only 14 families out of the more than 11,000 victims are still waiting for the individual compensation. This somewhat rapid advancement of the Chixoy plan, I would argue, is due to the fact that the government and victim groups have to report to the US Congress on the advancement of the reparation. So the advancement of the Chixoy case shows that financial restrictions on the Guatemalan government have been effective in obtaining results. Unfortunately, the close scrutiny of the Chixoy case has not translated in an overall institutional change in the government's agency, nor has it influenced implementation on other cases. This shows the purely transactional tactic of the government in accepting the Chixoy plan. We comply with the reparation and you give us our loan back, basically. The Chixoy case presents an awkward picture. International financial institution involvement in the reparation negotiation has permitted the compliance of a historic reparation scheme, and IFIs have taken responsibility for their lack of oversight. However, they failed to commit to contribution to the reparation in itself. This is insufficient. International financial institution needs to commit more significantly to human rights protection. They need to take responsibility for their faulty investment and rectify the situation they helped create. In contrast, Chixoy has demonstrated how IFIs can be involved in securing reparations for survivors. Delinquent governments show compliance only in the face of economical restriction. This tool is not to be ignored for the communities victims of gross human rights violation. However, it is not absolute. The case of Chixoy depended greatly on the political will of the US to enact that type of commitment. And even then, it did not promote institutional change, which is somewhat expected. To finish, I would like to remind the Reparation Fund law project proposed by the director of Adivima, which I think is very promising. It would ensure a bigger involvement of international financial institutions in transitional justice and would hold them accountable for their own investment. However, initiatives such as the Reparation Fund at the World Bank must be brought forth in conjunction with other mechanisms of reparation so as not to concentrate all resources on one case. Thank you so much for listening. Thank you, Professor Sandoval, for this great opportunity. I hope you're all safe and healthy. And if you have any question on the case, here's my email, and it would be my pleasure to respond. Have a good year.